Welcome to the Let's Be Real Estate show, where we talk about real stories, real experiences in the world of real estate. I'm your host, Darren Grella, and today we are diving into the topic of estate planning and probate process. Very excited to welcome our guest, George Poulos. He's the partner of Rischitelli and Poulos, based in Hudson, Ohio, servicing Summit and surrounding counties. He is an estate planning attorney, probate attorney, and trust administrator through and through, with decades of experience helping families in some of the most difficult times of their lives. So, welcome. Let's be real. So, before we get too deep, you've known about one of the owners of Exactly, Ben, for a number of years. How did you guys first meet?
If you know Ben, Ben is kind of an outgoing guy who likes to network.
Yep.
And came across myself and my law office being in Hudson, Ohio.
Yep.
And that's where his office was. And we struck up a friendship and over shared interests.
Yep.
And then started working together in the sale of real estate. His title company would handle a number of transactions for clients and did a very good job, and the relationship went on from there.
Yeah. So you've known for quite a while. I mean, he owned his title company for, I think, 20 years or something,
Yeah.
2 different title companies.
Yeah.
So
I want to say I've known him in excess of 10 years.
That's cool. All right, great. So you had you started off as a clerk in the probate court when you came out of law school.
Yes.
But what drew you in? What's your story there?
So my father was the chief magistrate of Summit County Probate Court for about 20 years.
So it was in the blood.
and he's with me now in the office a couple days a week, so it's a blessing to have him and practice law with him.
Mm-hmm.
But that's where I got my passion for probate law. Had the opportunity to do a summer internship at the court entering historical marriage licenses.
Okay.
So
Sounds fun.
marriage licenses, data gets uploaded to the internet at somehow, and that somehow for historical marriage licenses was me.
That's great.
But was able to have lunch and talk with the court staff and wonderful people, and some of those people are there, some of those people have moved on, but the court staff even today, we're very lucky in Summit County with our staff.
That's great. So you started off truly your father knew, you're very influential in the probate process. Did you know you wanted to go into law from the start? You were saying, hey, I want to follow in the family footsteps, or what was your thoughts there?
No. In school, in college, I thought that I was going to set the world on fire and get into international mergers and acquisitions.
Okay.
And then I realized that I don't like flying very much. Not that I'm afraid to fly, just prefer not to. I think it's more of a size thing.
Yeah.
And, you need to be able to do that.
Yeah.
So, and I did want to stay local as well. So that also was not conducive to my my path. Yeah. So law in the Akron area, Northeast Ohio, was a nice fit.
Was there one particular time where you're like, this is it. This is the path I'm taking?
I would say that going through law school, things fall into place.
Yep.
And I was fortunate enough to be accepted into the evening program. Okay. And many of those of my friends today, we're all still friends. And I was young at the time relative to my friends in the evening program, many of them. So they had families, they had other jobs. I also worked during the day and then went to law school at night. And it was being able to see how they functioned, how they were able to balance and manage family life and work and the stress of law school. It helped really put things into perspective for me, that you have more time, you have the ability to manage, you have the ability to prioritize your needs, and things that many people see as stressful or the most important thing, when you consider that you have a livelihood, you have a family to take care of, they're important, but not the ultimate importance. You know, and so that really drew me to a legal career. That drew me to probate, working with families, and all those conversations around the dinner table.
Yeah, for sure. It's important. Yeah. I mean, you mentioned stressful. Yeah, like the probate process is stressful, right? But you also do estate planning. Are you doing mostly estates? Are you doing mostly probate? Like, what's your book of business look like?
It's a pretty good mix.
Yeah.
There might be maybe 20% estate planning, maybe 40% estates and trust administration, another 40% through guardianships, and I will include litigation of those areas in that.
Sure. Yeah.
In that.
Well, that's a stressful time for families. Like if you're thinking through like planning for your future, have you seen where some estates do it great and they're handled nice and smooth, and other estates are kind of messy? What are some of those differences? What's happening? Like if I wanted a smooth estate after I pass, what's the path? Sure. What are the things I need to do?
So I'm biased.
Okay.
So first of all, I'm biased because my father was in the probate court, and as I said, you know, our probate court staff might, and the judges might watch this at some point.
Okay.
So I am biased.
Yes.
Probate is not a bad word.
Okay.
And everyone hears horror stories about drawn out estates.
Yes.
Everyone hears horror stories about families that didn't get along, or people who didn't do something, dot the I, cross the T, and then their wishes aren't being followed because of something. We all have heard those stories. But keep in mind, and it's also sad, there are thousands and thousands of people that pass away and have very efficient administrations, and their assets move on the way they want. We just never hear about them. And the reason why we don't is because it worked out very smoothly.
That's fair.
So, you know, probate is not a bad word. If your will is before the court and there are assets that are probate assets, by and large, it will work out. The overwhelming majority of these cases run smoothly and are very simple, not complex administrations. It's just we don't get the opportunity to hear about all the easy ones.
Yeah, that's right. So what we're hearing about is the mess, and people want to talk about that.
Yeah, and that's when people go to lawyers and have drawn out circumstances.
Yeah.
But generally speaking, estate planning can be a crucial tool to a smooth administration. So of course it starts with an estate plan, which is broken up into, do we want to go through probate? And there are reasons for that. Do we want to designate beneficiaries on accounts and have those pass outside of probate? You'd refer to that as a non-probate asset. Do we want to look at a trust? And if we are in the probate process, what are the rules to help have a smooth administration?
Okay. So if, I guess even backing up for the simple definition, if somebody doesn't know what probate is, how would you describe probate? If I'm coming to you and say, what is probate? You know? Sure.
Probate court deals with probate assets, and I will not continue to use the same word to define.
The same word.
So,
love it.
The probate court takes jurisdiction over probate assets. And probate assets are assets in the decedent's name alone, with no joint owner and no beneficiary. And so when I give this example, I prefer to cast my own death. So let's say I have a bank account just in my name. My wife is not on the account, and I failed to name any beneficiaries on the account. So it's just in my name alone, no joint owner, no beneficiary. I pass away. My wife goes to the to the bank and says, that's my husband who passed away. Here's his death certificate. May I have these funds? The bank says, ma'am, I'm sorry. Appreciate that you brought in the death certificate, but you're not on the account and there's no beneficiary. We'll need to see some letters of testamentary or some court paperwork before we can release this account. So then she goes back to the office, gets my will, meets with an attorney, fills out the paperwork, goes to the court. The court then intakes the paperwork. My wife is the beneficiary. Love you, honey, if you watch this. And gives her the court appointment. She goes back to the bank. They intake the court appointment, and they close the account and issue her a check payable to the estate of George. She then puts that into the estate checking account, pays the bills that have come in a timely manner, and then distributes the remainder to herself as the beneficiary. So that's typically how the probate process works. It can be very smooth and simple, but again, had I put a beneficiary on the account or made it joint, none of that would have been necessary.
So in that example, does a person go to the bank and make sure the beneficiary is added on there? It doesn't have to be a joint account, but just saying, hey, beneficiary goes to my wife. And
so it's all part of your estate plan. And I do recommend people meet with an attorney, and most attorneys will offer a free consultation. Or, don't charge to pick up the phone and at least inquire. But what I have everybody, all of my clients do, is make a list of their assets and how they're titled, and whether there are beneficiaries designated, and then whether there are contingent beneficiaries. And then see what their family situation is, and then see what their goals are for what they want to have happen with their assets. And then that kind of fits in place what goes on with their estate plan.
So a few things in there, like let's pretend, if I'm dealing with my parents who are seniors, that they say, oh, I did a will back in the 70s. Like, you'll be fine. We already got a plan in place. So and that was before I was even potentially born, right? Depending on when they filed it, which I think that in my case it actually was. How often should somebody look at their estate plan?
Sure. I would say at least every 5 years, or the sooner of a major life-changing event, or every 5 years. Obviously, when you do an estate plan, you do an analysis of who those people are that are closest to you in your life. Not just who, we all think about who we want to give our stuff to, but I focus on, because I get a lot of calls about emergency situations. So I look at more health, like a healthcare power of attorney. So when we do our estate plans, we're thinking about people in our lives who can make decisions for us in an emergency situation if we can't make them for ourselves. And you know who those people are. So God forbid anything happen to those people, that is a time to reevaluate and reconsider, what's in your estate plan, and possibly talk to an attorney about updating those documents. And again, there's almost no reason not to have a conversation. Because once the emergency happens, then it's kind of done.
Got it. So you mentioned beneficiaries, like in your previous example. How do you know who and for what? Is it on just big assets like a life insurance? Well, if you don't have life insurance, what about like your cars? What about all this, like thinking through the beneficiary process? What is that? How does somebody even approach that?
So first, you're looking at where do I want my resources to go, and are they going to go with strings attached over and be distributed over time? Are they in cash, or we say in kind? Is a car, or is somebody wanting cash? And then how do we get that asset to that person, and is that person capable of receiving it? Now, again, lots of horror stories about all these things. I think in college, There was a young man in the dorm I believe his father passed away, and then he showed up with a Corvette and a Yukon Denali.
Okay.
Now, maybe for his family, that's a great use of funds, but maybe you don't need two of those
Right.
in
Right.
a college dorm. But
Yep.
good for them. Hope they're doing well. But you want to marry your wishes with the capabilities of your beneficiary. So just generally speaking,
Yeah.
when you designate someone a beneficiary on a bank account, while you're alive, they have no current access to the funds.
Okay.
A joint owner, however, is an owner. They have current access to the funds. So that's the difference between a joint owner and a beneficiary. A beneficiary has an expectation they will inherit later.
Okay.
A joint owner has immediate access and ownership. And in both scenarios, if a joint owner were to pass away, the surviving owner has sole ownership of the account.
Sure.
Upon the death of all owners of the account, then the beneficiaries would receive ownership.
Got it.
Now, if a beneficiary happens to be a minor, the minor is not going to receive the assets, and that would trigger a minor guardianship in order to pay that money out. So now you're back in the probate process.
Yep.
So typically you would not want a minor to be named a beneficiary.
Okay.
You would want to use a will or a trust to give assets to a minor. Similarly, someone who might be disabled.
Yep.
They're receiving some type of governmental subsidy to help with their life.
Sure.
And the receipt of funds may not help them in the way that you intend.
It's true.
So even though adding beneficiaries is extremely convenient, and by example, when somebody does pass away with a beneficiary, the beneficiary shows up with the death certificate, and then it's more of an immediate process, weeks to less than a month to receive funds, prepare claims packets, and receive the funds. The probate process can be shorter than 6 months, but I generally tell people 6 months to a year. Obviously, again, you hear the horror stories, but
Sure.
More often than not. I mean,
Sure.
overwhelmingly more often than not,
Yep.
6 months to a year.
Okay.
And then that's where trusts come into play. If you want to extend out the time period for somebody to receive money, then you would look at doing a trust. But really, when you're considering adding beneficiaries, and again, most people, overwhelming majority of clients, they have spouses, they have children. If they don't have spouses or children, they have people who are their quality people in their lives that are good people that they want to have their resources, and beneficiaries will work to do that efficiently. But in situations that are not, it's still not a one size fits all.
Got it. Yeah, it's as obviously each situation is very personal to that. But what if somebody dies without a will? How do you find what's next? I guess somebody steps up and says, "Hey, I'll take care of this."
Right.
But are they actually the administrator, or does the court appoint that, or is the attorney be the administrator? Who's in charge if there's no will?
Yes. I love answering yes.
Okay.
All of the above.
Okay.
Anyone can administer an estate.
Great.
And if you meet the qualifications, if you're an Ohio resident, even creditors can administer estates. But there's a priority to it. So spouse and children and family members who are local are a priority. The counties have their local rules on whether or not out-of-state family can try and administer an estate and whether they'll accept you with or without assistance. But generally speaking, there is a priority, and you'd have to meet the criteria. One of the main advantages to doing a will is the waiver of a bond provision.
Okay, what is that?
So a probate bond is an insurance product that protects against theft.
Okay.
So the person named as the administrator of the estate is required to have this bond at 2 times the amount of personal property that's in the estate.
Okay.
So if the administrator were to leave with the funds or steal, then the insurance company, based upon their credit, will pay out and then go after, the wrongdoer.
Mm-hmm.
Now that's when you don't have a will. You're an administrator.
Okay.
When you do have a will, you are an executor.
Okay.
Now, one of the advantages of doing a will is that you pick people who won't steal from you.
Hopefully.
Because if you're thinking, hey, maybe this person might steal from me,
Sure.
then don't put them in your will.
Yeah. Or at least don't have them as the executor.
Yeah, let's not name the thief as the executor. Let's use somebody else.
Yeah.
And
good call.
but one of the advantages of a will is that you can dispense with this bond requirement.
Okay.
So I mean, there are different reasons why someone might not have the best credit or might not be bondable that are completely legitimate. Doesn't make you there are bad people with excellent credit. There are great people with poor credit. But the requirement of a bond is a requirement, and it is based in a large part on creditworthiness. So if you are intending to have certain your desired person to administer your estate, that's one of the advantages of having a will. You can dispense with that bond requirement.
Got it. Well, how about like these administrators and executors or executrix have a fiduciary responsibility to the estate?
Yes.
Can you speak to that responsibility? Like
yes. Oftentimes there is a difference between being an executor administrator. That would be you're a fiduciary. You are responsible for doing certain tasks on behalf of others. So the court is putting you in charge. You're not owning. You're a temporary custodian with the responsibility to perform the tasks outlined in the will. Sure. Or if there is no will, you're responsible for the tasks required by the Ohio Revised Code in your estate administration. So your responsibility ultimately is to those beneficiaries and creditors of the estate to administer the estate in according to law.
Got it. From a real estate perspective, we hear of stories. Obviously, we're not in the courts and we don't know like what's actually happening behind those doors, but where an administrator or executor is not caring for the real estate property effectively. So the house is, maybe there's a roof leak and they're not attending to it, and the process takes several months, really, maybe a year. The property sits there cold. It's not winterized. It's not maintained. And so the value of the property decreases. Is there a responsibility on their part to maintain something like a real property?
Yes, it's very tough. And the reason why I say it's tough is you are accepting responsibility when you fill out the paperwork.
Okay.
No one is requiring you to step up to administer an estate. Even if you're named in a will, you may want to take that on to carry out your loved one's wishes, but you're not required to do that. You can waive your right. You can consent to somebody else serving.
Okay.
You can hire a professional to do it. To speak directly to your question, there's no requirement that anyone who serves as an administrator or executor advance their personal funds to carry out the duties of the administration.
Okay.
However, you are required to act in the best interests of the estate, and there is a range of reasonableness there. Now, ultimately, who determines that range is the probate court when something goes wrong. Because when everything goes right, it goes right.
It goes right. That's good.
We just went through a period, as you know, of high property values. I don't know where we are right now. Maybe we're still kind of up there, but not the peak of the peak.
Right.
So what if you had an estate that was opened in 2020 or 2021, and you're like, man, my brother is really dragging his feet on this. But what if he then sold the property in 2023 for 100 or 150,000 more?
Right.
It worked out really well.
Right, it did.
But what happens if he's dragging his feet today and 2 years from now sells it and the value went down with all the property taxes? Then you're going to be mad.
Yep.
And what was one scenario, a delay was a good thing. It may have been on purpose or by accident. And unfortunately, in another scenario, that delay didn't work out. So to answer your question, there's a wide range of reasonableness, but that's why you want to engage an attorney to help advise you on where that line is, to make sure that what you're doing is within that range, because only with experience can you have your best arguments to the court if somebody felt like you didn't do the right thing.
I've had actually a couple people ask, can an administrator be paid? Can they receive compensation for caring for mom's estate?
Yes. So there are statutory provisions that allow for the payment to the administrator. Typically, that occurs one time at the end of the estate. There are times, we say if the estate goes beyond a certain time period where an annual accounting or a partial accounting is required, because the estate's going to go beyond, let's say, 9 months or a year, then we'll do a partial accounting, and the fiduciary, the administrator, executor can receive a partial fee. But it's typically in the range of 4% of the first 100,000 of gross assets, 3% of the next 300,000, 2% thereafter.
Got it.
That's a general.
And the asset value is not necessarily just what's in the bank account, it's the full estate's appraised assets.
Yes. And it can include non-probate property that the executor or administrator is involved with as well, at a smaller percentage.
So there is it's almost like taking on a job. It's very stressful.
It is. And those fees that are paid to attorneys and executor or administrators, those are it is a job. And it's treated as compensation, and it is deductible against income for the estate.
How much time would it take an administrator? I mean, obviously, the answer is yes, right? Or the answer is depends, of course, right? But it's like, what should, like the average estate, what should somebody expect? If I'm the administrator of our family's estate, like, is this like 20 hours a week? Am I dealing with 20 hours a week times 12 months? Like, is this, what's the...
You never try and pin down a lawyer. Come on now.
Tell it to the wall.
Every lawyer with their clients handles things their own way. And so when I say this, some lawyers will shiver, some lawyers will agree. And to the extent of some lawyers will maintain the estate's checkbook in their office and want the client to schedule a meeting before any check is written or anything is done. How I can only speak for my practice. So I try and tell my clients, the more work you do, the less the bill will be. However, my caveat to that is that there are certain court requirements that I have to sign off on, and certain documents that have to be prepared. So I need to be included in the preparation of those documents and to make sure that we are doing things according to law. But things like mail forwarding for the post office, calling the banker to schedule the appointments for liquidating bank accounts, meeting with the realtor. Yes, you can absolutely have your attorney do those things for you and schedule those things. You will pay the attorney or their paralegal to do that. Or the estate representative can do a lot of things and simply have a brief phone call and say, hey, here's what I have lined up, or am I on the right track?
Yep.
And then you save the estate a lot of money, but your time
Is
in administration increases.
Yeah.
So it all depends, and I know that's not what,
That's
what
okay.
you want to hear.
Yeah, it's like if I'm an administrator, I just want to kind of generally know. So there's a lot more that you can do, and the more that person does, the less the attorney bill will be.
And the other thing is, I think having a good attorney-client relationship is about the expectations and what's coming down the line.
Mm-hmm.
And the closer you are to setting expectations about the responsibilities and the court requirements and when things need to be done, the better relationship you'll have with your client, and also the client will feel like they have a better handle on what they're supposed to be doing and when it's due. And I think that helps a lot.
Yeah, it's interesting. From an administrator's perspective, like it is like this battle because you're dealing with the emotions of everything as well, and all the personal properties, and then all the potentially real property and just the emotions of the whole thing. Like, how much do you get involved in the emotions of an estate? Because this is like, yes,
Sure.
You're dealing with facts and filing paperwork in the court, but also there's a whole nother component that we haven't addressed.
Absolutely. And it's typically the emotions are around things that are not valuable, from a monetary perspective.
Sure.
That's where you find you spend a lot of that, mental anguish, and you have a lot of tough conversations. Maybe there's only one antique that mom really loved, but there's 3 children. You can't break it into thirds.
So what do you do as an attorney in those cases?
So you look at different ways. So everything's important, but how important is it?
Uh-huh.
Obviously, if it's important to everybody and there's just one, and money is not a solver, then you can come up with an agreement among the group where maybe you pass it around, in certain time intervals, or you allow everybody to have access to that item.
Mm-hmm.
But if there is a way to solve it, you can do auctions, you can do a bidding process,
Okay.
you can draw straws,
Wow.
you can everyone loves fantasy football. You do the snake draft.
Okay.
The person who gets first pick, the last person gets 2 picks, and you go back down.
Uh-huh.
You try your best to equalize things among beneficiaries who are equal.
Sure.
And but emotionally, you deal with all of the family problems.
Mm-hmm.
And so you have, well, this person did this, many years ago.
Yeah.
I don't understand why this person did that.
Mm-hmm.
And so you have the decedent's wishes and you have the law. And
Yep.
and I would just say, barring those circumstances where somebody's taken advantage, I try and encourage people to think the best of their loved ones.
Okay.
And even though maybe you think they got it wrong, they probably weren't thinking that when they were drafting their estate plan.
Sure.
You want to give your loved ones the benefit of the doubt that they were using their best intentions.
Mm-hmm.
And obviously there are family members that we just don't get along with.
Yep.
But
Not in my family, by the way.
of course not.
We all get along.
You choose your friends, but not your family. But oftentimes there are family members that just don't get along. But you try and at the end of the day, you have responsibilities to the court and the law, and you do your best to equalize all of those things despite your disagreements.
Mm-hmm. So, excuse me, in the world of real estate, which is our world, interact with folks like yourself and these, what gets messy when real estate's involved?
Everything.
Yeah. All right. So, Yeah, do tell.
And I don't say everything. The idea behind going through probate, and one of the values of the probate process is that you have one decision maker. You have an executor that's been named.
Okay.
And yes, there are circumstances where you have co-executors, but those are more rare. You have one executor, one decision maker with authority outlined in a will to make decisions. So that has the ability to streamline a real estate sale. You're empowered. You don't need any additional court authority because the will has given the executor power to sell. Okay. They go in, they meet with the realtor, they choose a realtor, they choose a title company, they move forward with a contract, they sell the property, and it goes smoothly.
Sure.
So if family members want to complain, they can do that, but they aren't decision makers.
Okay.
When you designate beneficiaries on title to a piece of real estate, what you're doing is you're creating a partnership among those. Okay. So, how many brothers and sisters do you have?
So there's 3.
Okay. So there's 3 of you. How many of you are married?
2 of us.
Okay. So that really there would be 5 of you. And what I mean by that is, let's say your parents decided to name the 3 of you as beneficiaries of a piece of property by transfer upon death designation. Parents pass away, the 3 of you are now co-owners of this piece of property. Now you have 3 main decision makers, but wives have to sign off on the sale of real estate too.
Okay.
So they have a seat at the table.
Yep.
So now you have 5 opinions. So which realtor are we going to choose?
Yeah.
Whose buddy gets the? What are you going to have? 5 realtors, 3 realtors, 2 realtors? How many? And then, do we paint the house? Well, who's going to give the money to paint the house? Are we going to do all these things, or are we going to sell it as is? What are we going to do? Yep. And that's where, the best intentions of the decedent was, I want to avoid probate. Yeah. Let's give our 3 children this property, and then they will work together. But will they? And that's a conversation with your attorney to have, because your best intention was they'll work together, but now you've created, a blending of these opinions, and there's no good way to resolve it other than, unfortunately going to court.
Yep.
One of the values of having a probate administration or a trust is that you do have that single decision maker that can kind of referee the disputes with their one vote. And that's not to say that people don't get along on beneficiary designations. It's just an analysis that's to be done with your attorney before you just say, I want to avoid probate and not think anything of it.
It's complicated. Yeah, we've found that families get stuck. There's when we're dealing with folks that are going through this, it's interesting. They're stuck, and we're trying to figure out what is the stickiness? Why are they unable to move forward and make a decision, which tends to drag out, the process. But a lot of it is just this almost like an embarrassment. Like, oh my gosh, I can't believe the property got to this, is this poor. I didn't realize she had this much stuff. I didn't, they're almost like embarrassed of the actual property, and it feels so overwhelming that they are just frozen. Do you see this when you're dealing with families, or do they come to you with a plan already in place and saying, here's what we're doing?
Well, yes, there are circumstances where family members may not realize, or friends may not realize the extent of what somebody was going through. And there's some remorse or some guilt over those scenarios. More often than not, we put the people in charge in our wills who are the closest to us. And they have some experience with the living circumstances and what went on. And so when people get stuck, I find it's more about, I love this place.
Okay.
I have fond memories here. Or
Yep.
I just can't bring myself to part with X, Y, or Z, even though that's what I'm supposed to do.
Yep.
There's a requirement, to take on these fiduciary responsibilities and follow the court rules to administer the estate, but also, everyone's going through a grieving process.
Sure.
And there's no rules regarding a grieving process. You can't tell somebody, oh, you should be over this by now.
Right.
Absolutely not. Everyone has their own process. Some people can't start their grieving process until the estate is closed, because they feel like that's an extension of of the passing.
Yep.
And they can't. So, unfortunately, the best thing to do is consult with your realtor, consult with your lawyer. You have your team. You're going to hire probably a realtor to help you with the sale. I don't recommend people do for sale by owner, because you just don't know. You don't know what you don't know, and you may not have access to the highest and best price. And I do think there's value in having a realtor find the market for this. And realtors, I think, are similar to attorneys in that they will give you their time for free to consult with you on the market value of your property.
Sure.
So that can help head off some of those delays. Again, setting those expectations. You have your lawyer who can advise you and help you get through any stumbling blocks. You have your accountant or financial advisor to help navigate maybe some tax issues or some financial constraints, about going back to what you talked about with, do we spend money on, upgrading the property? Do we remove all this contents? Do we hire somebody to help remove contents? Do we remove the contents and tear up the carpet? Where is that line? Are we creating a money pit? With you may not know those answers yourself, but as a team of professionals, you can come to that answer in a financial analysis. You can come to that conclusion emotionally with how you want to go through the property and dispose of it.
Sure. Yeah, it's a lot. And that's where we've our experience is that we come in with families and saying, hey, what's the best way for them to move forward and figure out that plan? And it can be overwhelming from what we've seen. That's interesting. Yeah, I love, of course, being biased. We can be biased too, but like your team is getting the right attorney, getting the right, if you have real estate, getting the right real estate professional in place. We would argue that they should be certified in probate, selling probate real estate, understanding the timelines, realizing the communication is critical, realizing decision makers and the court process and that, and then communicating back with the attorney. Do you have good relationships typically with these? Like the family says, hey, here's what we're doing, here's the real estate company we're using. Do you tend to communicate well with those types of, you have to, right? But are there any keys that you see? Like how often is the right communication with the property?
Sure.
Anything working with a real estate agent?
It all depends. And I know I keep saying it all
It's
all
okay,
depends.
that's the attorney answer.
Yeah, I know. And it's a habit that I don't think I'll ever.
Don't break it. It's okay. Because it really does depend. Yeah.
So how do you, it goes back to how do you receive a client? Are you receiving a client on a referral from someone who knows you? Are you receiving a client from somebody that was referred by somebody else? And so what I mean is, so maybe the client knows the realtor and that's their trusted friend, and the realtor then says, well, we need an attorney to help us. So that's where, the realtor has that client interaction and then is relying on the attorney to fill in the gaps of expertise. Maybe the client finds the attorney and then the attorney recommends the hiring of the realtor, whether that becomes a realtor that the attorney has actually referred the case to, or the client says, oh, I do need a realtor, I'm going to go choose, of this list of people that my family knows. And so that interaction, you don't necessarily know what everyone's level of expertise is in a certain situation, but ultimately it's up to those professionals to share in a meeting or multiple meetings what the requirements are, what the different options are, and have the client make the choice as to how they want to proceed. And I think a skilled realtor and a knowledgeable attorney will sit down and say, okay, let's assess the value of the property as it sits today. Let's assess the value of the property, assuming there's money to do some upgrades. What does that look like? What is the return on that investment? What is the time period? Because property taxes don't stop. They're always accruing.
Yep.
And we never know what the interest rates will be, going forward. They may, hopefully we're not in a period of rising, but and that we're at a period of going down, but that may play a factor too.
Sure.
But you ultimately don't know, and time has a cost as well. You talked about the emotional side of things. Yep. What is the cost of holding on to our family's property for another 3 months, 4 months, 6 months? Do we really want this hanging over our head over, a certain amount of money? There's no crystal ball to see the future, but as a team, you can sit down and iron that out. And so it's up to, those who are closest to the client to discuss with them the different options and have a good plan in place from an educated perspective on how to move forward.
Yep, that's good. Yeah, that's a critical. Building that team and then that communication. That's essentially what happened with Exactly. And this isn't exactly commercial, but we were realizing families and administrators go through so much more than just putting a sign in their yard, and you really need to figure out how to help unstick them in these situations. So that's very helpful information, like how a real estate agent and an attorney can work better together by working through the value. What if you're looking at an estate, you as an attorney now, not necessarily just real estate, but you realize there's no money in this estate. The debts outweigh this estate's value. What do you do? Does everybody just stop and be oh well, let's hope this thing goes away? Or do you keep going through the probate process? Who gets paid? Take me through it. What if there's no money in an estate?
Sure.
What do you do?
So I guess first of all, when you have an administration,
Yep.
you don't have a will,
okay,
you can sell property in two ways. One is through litigation, and I know that sounds bad, but it's not really. You need court approval to sell the property, and that's called a complaint to sell real estate. And that can be to pay debts or just to have the authority to sell the property. Because as an administrator, we don't have that authority in a will, so we have to derive that authority from another way. And that's either through the filing of a complaint or through the consents of the heirs. And when there's a property that is either underwater, the debts exceed the value of the property, or it's close, or there's a big mortgage payment and there's no cash, that complaint to sell process can be used in order to preempt the mortgage company. You're effectively foreclosing on the creditors. And there's a priority of who gets paid out of the sale.
I did want to ask you about that,
Yeah.
this race to the courthouse.
Yes.
Right?
And so aside from that, we all want our family members to pass with dignity. And that involves, paying for their final expenses, disposing in a timely manner of their assets, and trying your best to accomplish their wishes. So aside from, just controlling or receiving a profit from an estate, there's a dignity to the administration.
Okay.
And so what you can do is you can utilize that complaint to sell process to the mortgage is still accruing and the amounts are due, but they aren't able to file a foreclosure if you file your complaint to sell first.
Okay.
And then in that sale process, subject to court approval, of course, the caveat, there's a fiduciary fee that can be paid based upon the value of the house, an attorney fee that can be paid for doing that work, some expenses of the sale that are approved by the court, and then the mortgage company or the creditors that have attached liens, they would come next. So you would receive a portion of compensation. You would have the ability to have some of these estate expenses paid out, and you would have the ability to dispose of the property rather than letting it fall victim to blight or foreclosure. And that's a very detailed process that would require, that I highly recommend having an attorney for, but is a nice tool in the probate toolbox to help people through administrations.
That's great. There is, and I mentioned this briefly, by the rush to the courthouse, like in who gets paid. Can you speak to the filing process of that real quick?
Sure.
Like who's...
So in order to open an estate, and I'm speaking to our local court, they would like to see a death certificate and the proper paperwork. And if you have a will, then the person named in the will would get appointed quickly. If you don't have a will, then you would need the next of kin, who are of equal degree, to sign off on the appointment of a particular person if they're Ohio residents. And so if you want to be appointed soon, you want to get everyone on board with the process. Otherwise, the court's going to have a hearing on your appointment, because the court doesn't know whether anyone is contesting your appointment or not, if you haven't filed consents and waivers. Mm-hmm. So if you want to expedite the appointment, you have to get the heirs on board. Once you're appointed, then you can go through and file this complaint to sell real estate in this situation. Another important thing to note is that, and this is one of the pitfalls in these estate matters, and why it's always good to have that consultation with an attorney and a realtor as well in these short sale situations, is that just because you advance money does not guarantee that you will receive that money back. So for example, let's say there's a mortgage that's due. The mortgage company is the one that holds the lien on the property.
Correct.
If there's no equity in the property after the satisfaction of the mortgage, how do we pay the person back who's advanced the payment on the mortgage? There isn't a way to do that. So it's important, again, I keep talking about having a team and taking advantage of, these professionals' time. I mean, that's how lawyers and realtors receive clients, is they have conversations. And if you demonstrate a level of expertise, that you might be able to do business. If you don't, or the client doesn't feel comfortable, they move on to the next person. But it's important to understand what the rules are in a particular circumstance, know whether the assets are intangible cash assets, and who the priority creditors would be of those assets, what the law is, what debts are associated with the real estate, and who gets paid in priority out of those. Because what you don't want is a situation where somebody is advancing and paying in good faith, but then there's no ability to get them paid back.
Get them repaid. Interesting. So, can you speak to just high level the priority of payment? So I have heard like funeral expenses are a really big piece of getting paid. Like, tell me about that. Who has priority? Is it taxes? Is it funeral? Is it attorney fees? Is it who gets what first?
Yes. I did it again. So you're in real estate, so let's break it up into a couple of categories. One, we'll say lien holders in this hand,
Okay.
and then we'll say general estate debts in this hand.
Okay.
So lien holders, a car loan,
Yep.
a mortgage,
Yep.
they have priority to collect on that particular asset.
Okay.
So they get paid first when those assets sell. If they're otherwise not paid out of the assets on the other side, the cash assets,
Sure.
those assets with equity.
Mm-hmm.
Generally speaking, outside of lien holders who have that lien, that encumbrance on that property, the law provides for the payment of the administrative expenses, the fiduciary fees, the attorney's fees, the funeral bill as a higher priority.
Okay.
And then as far as creditors go, there's a list of who gets paid in what order.
Mm-hmm.
And so you have, these group of upper level expenses, the costs of administration, the fiduciary fees, the attorney's fees, the funeral bill to a large point.
Okay.
And then, if the individual was on Medicaid, receiving, not Medicare,
Yeah.
Medicaid, receiving government assistance, then they're, that heightened level of creditor priority.
Yes.
And then eventually you get to all the general creditors in one pot.
Okay. So it's almost like if there could be money in the estate, it gets dwindled down with debts and things.
Sure.
And then hopefully, there's some leftover
And yes,
for the family.
And you had asked, that I think at one point, what areas are become challenging where
Yep.
where you run into a problem. And in that initial conversation, it's important to analyze when can we actually receive a creditor debt?
Yep.
When can a creditor present a claim?
Mm-hmm.
And there's a certain time period. And what happens if we receive a bill? Do we just pay it, or should we wait? And that's one of those things where you don't want to not call your attorney and say, hey, what do I do with these bills?
Sure.
Because if you pay things out of priority,
Mm-hmm.
if you pay debts that are not due or haven't been correctly presented by a creditor, they're not likely to give you the money back.
That's right. That's right.
You paid, and
That's
and
right.
that's it. And so what I generally say is, the debts of the estate are only the debts of the estate. We are not obligated for debts of somebody else.
Okay.
And just because you are the estate representative, you don't have any personal liability
Yep.
for paying someone else's debts. Now
Right.
you are required to use the assets of the estate to pay the estate's valid debts.
But not your personal
Not
funds.
your personal funds.
Mm-hmm.
And so it's important to have a communication with your attorney
Yep.
on what bills have come in,
Yep.
what assets there are, and how are we going to pay those bills, and if we should pay those bills,
Mm-hmm.
do they meet the criteria for presentation of a claim?
Mm-hmm.
And it's kind of a nuanced process, and
Sounds like it.
and also it starts when the fiduciary is appointed, and it ends at 6 months date of death.
Okay.
And Medicaid has a little bit of a different rule. You're required to give them notice, and then they have a time period to respond with a claim.
Okay.
And if you don't give them notice, then that's extended out.
Mm-hmm.
But generally speaking, it's from the initial appointment to 6 months date of death.
Okay. For the initial appointment, that can take a couple months post-death, correct?
Yes.
So, maybe there's only like a 4-month window for creditors to file.
Sure. And but as I said, even a creditor can be appointed to administer an estate.
Interesting. Why would that happen? How? Yeah.
So
In what circumstances would a creditor be named as an administrator?
let's say that you're owed money,
Okay.
and the person who owes you that money has passed away.
Okay.
You know that they have real estate or that they have
Okay.
some kind of asset out there,
Okay.
and the estate's not being opened, you're bound as a creditor. You're bound by that 6-month period, and so what you might do is engage an attorney and file to open the estate so that you can preserve your claim.
Wow.
And so, I do caution clients. Yes, you may be waiting the 6 months, but be careful, because in doing so, someone else may try and seek appointment, and then you may not look the best to the court by saying, oh, the reason why we didn't file to open the estate is because we didn't want to pay these bills. That's not the most endearing statement to the judge.
Yep, for sure. Gotcha. Great. I could literally talk for hours about this stuff and learning and gathering info. So, is there anything specific that you're saying, hey, we should at least talk about this while we're here?
Yeah.
Any other topics to wrap up?
I would like to say one thing about paying of claims and the difference between probate and non-probate beneficiary designation. So a lot of people don't know that when you are a beneficiary on an asset, a bank account, a life insurance policy, there is no legal obligation for you to use that money to pay debts of the decedent.
Okay.
You also aren't legally obligated to share that money with anybody. Okay. That is a direct receipt. Again, going back, the death certificate is presented to the bank cuts you a check. You are not obligated to share with anyone or pay debts. Now, if you do, you decide you have done that, and they're not going to give you any money back. Okay. But a lot of people don't realize that there's, maybe there's a moral obligation that you feel, but legally, if you are the beneficiary of an asset, you are not obligated to then share or pay any debts associated with the estate.
Interesting.
The probate assets are used to pay probate debts. If there are not enough assets, then the debts get paid in proportion or not at all, depending upon the priority.
So in simple terms, if I'm looking at an estate, these assets have been named, beneficiaries have been named, those can kind of be pulled out of the estate? Is that kind of what you're saying?
Those are non-probate assets outside of the court that transfer directly to the beneficiaries and are not subject to the debts of the estate.
Okay. Is that just a bank account? Is that just a life insurance? Like, what else would there, anything? Yeah.
So for example, let's say you transfer upon death real estate that has no mortgage.
Okay.
That goes to the beneficiaries outside of probate, transfer upon death.
Yep.
And if there are large debts in the estate, medical bills, what have you, they are not coming against the property, because that went non-probate, transfer upon death.
Okay. So are there like these transfer on death designations? Maybe speak to that. Is that something we should do on all of our assets then, or what?
It all depends again, and it goes back to, we talked about that example with you and your family, and there's 3 siblings, and so we're weighing, by making it a probate asset, it'll be subject to potential debts that we don't know about, but we get one decision maker who can solve all problems.
Okay.
If we name beneficiaries, we might be, putting people together who disagree, and that may cause some dysfunction, some family drama that isn't what we want. And so we're weighing the best scenario and these factors, and it's not easy.
Yeah. Wow, that's great. Yeah, I look at our family, our scenario. My older brother is the executor. We have a trust in place right now, so it's like he's the executor. There's me. My younger brother is deceased. No spouse or siblings or children, and then my younger brother with his wife. And so it's an interesting dynamic. And then you look at we talked a little bit beforehand about, adoption and how that kind of comes in, and, siblings of full blood, and then between the two parents, and then you have divorce situations, which, statistically 50% of, marriages have divorce. So then siblings kind of get mixed. That sounds like a pretty complicated estate, if you will. These are folks that probably should do something ahead of time. But like when you have a super complicated heir tree, or what is that called? What would that be? Just heirship or what?
Your next of kin.
Your next of kin. So it's very complicated. How do you deal with that? And then the emotions there and everything, the complications of that.
Sure. So when we do estate planning, if you designate a beneficiary, they receive the assets. If your assets go through the probate process, then you are not able to disinherit a minor child or a spouse.
Okay.
So they're in, if you have probate assets with a will, if I would never do this to my wife, but if I said everything to my best friend, she would have rights under the law to say, nope, these probate assets are going to be mine, per the law. Okay. You can't disinherit me.
Okay.
Now, you can disinherit through a trust, though.
Okay.
You can disinherit through beneficiary designations. Okay. I've had a number of unfortunate situations over the years where a surviving spouse will come in and say, I'm inheriting through the will, everything's to me, but then the life insurance is to a nephew.
Oh.
And that's, very troubling because, if the person intended to do that, then that money's not coming to the spouse.
That's right.
If it's to the nephew in the will and you have the surprise reading of the will and everything comes into the will, then the spouse has some rights. If somebody creates a trust and funds the trust, some, like you said, divorced families, they may use a trust to say, okay, my assets that I brought into the marriage are going to be in my trust and they're going to go through my family line, and you're going to have your own trust and it's going to go through your family line, and we're not going to blend.
Yep.
Whatever we have together that we create is going to be to the survivor, and we're okay with that because we have our separate property.
Okay.
But with planning, you can accomplish all of these goals and uncomplicate it.
Yep. So when should someone, I keep asking questions, we're trying to wrap up, but when should someone start an estate plan, right? I guess, from my perspective, it's like, I'll get to it eventually. Yeah. And, but when does someone start one?
Yeah, I mean, I think it's always a good idea to have an estate plan. Okay. And again, just me, I worry more about that health emergency where, because the hospital occurs first before somebody passes.
Sure.
Unless it's a shock moment, but typically there's an injury, and there's decision makers that need to come in. The finances are important too, but you need to stabilize somebody's health first. And so there is value into estate planning well beyond just doing a will.
Yep. And
even if your will is very simple, all to my spouse and then my children, you can meet with that attorney and prepare your financial power of attorney and healthcare power of attorney and living will to make sure that while you're alive, those emergency health situations, those emergency financial situations are handled. And so the time is always now.
Yep. So from what I'm hearing from you, the one thing someone could do this week to better prepare their future is healthcare power of attorney.
Yeah, healthcare power of attorney.
Just a little thing that they can do this week. Yeah. Is that something they can do? Should they do it through an attorney, or can they do it independently? What's the process of that?
So I always recommend the advice of counsel. However, the state of Ohio has created a form that is widely available.
Okay.
Most hospitals have them available. I believe our local probate court
Okay.
has them available,
Great.
or resources to help you. But it's all part of the estate plan. And I think if you look at it from a perspective of not, this is something we need in the future, this can help us with an emergency that occurs now.
Today.
I mean, something as simple as, I'd love to help my spouse make a doctor's appointment.
That's
Well, how do you have legal authority to do that? You don't.
Yep.
I want to help my brother or my sister, my mom or my dad, with talking to their doctor and asking questions.
Yep.
How do you have legal authority to do that? You don't.
Yeah.
My banker is asking complicated questions. I want to help, or I need help with answering those questions from my family. How do we have legal authority to do that? Without a power of attorney, you don't. So you can use in your mind, say, this isn't something for the future. I would like to empower those around me who I trust to help me now, and meet with an attorney to put those people in place so that I have a better chance of getting my desired information on medical and financial questions.
Yeah, that's great. Anything else to wrap up? I know we talked about a lot, and there's probably some rabbit holes we can go on for the next few hours, but we'll have to have you back.
Love to be back.
It'd
Happy
be
to
great.
help.
Yeah, it'd be great. But awesome. Thanks so much for joining us today, and we'll look forward to future conversations.
Thank you.
Yeah, yeah.